Hello and welcome to this Federalist Society webinar. This afternoon, December 19th, we have a webinar on a litigation update on this case. Remind me again the name of the case, Jonathan?
Alliance for Fair Board Recruitment versus Securities and Exchange Commission.
Perfect, thank you. My name is Ryan Lacey, and I'm an Associate Director for the In-House Counsel Network at the Federalist Society. As always, please note that all expressions of opinions are those of our expert on today's call. Today, we are fortunate to have an excellent speaker in Jonathan Berry, who I will introduce very briefly. Jonathan Berry is a managing partner at Boyd & Gray PLLC. He formerly headed the regulatory office of the U.S. Department of Labor and served in the Department of Justice's Office of Legal Policy. After our speaker gives a description of the case, we will turn to you, the audience, for questions. If you have a question, please enter it into the Q&A feature at the bottom of your screen, and we will handle questions as we can towards the end of this afternoon's program. With that, I thank you all for being with us here today. Jonathan, the floor is yours.
Ryan, thanks so much, and thanks everyone who's joining in for this. Really glad to get to share news about this decision. So this case has its genesis just about 4 years ago today, when the Nasdaq Stock Exchange submitted the original version of its proposed rule on diversity, which we would refer to in shorthand as a board diversity quota rule. But to understand the posture here, it's necessary to talk a little bit about how stock exchanges are regulated by the Exchange Act. Ever since 1975, a feature that comes up a lot in the court's opinion, which I'll get to. Ever since 1975, for stock exchanges like Nasdaq and the New York Stock Exchange, which are of course the two big ones, in order for those exchanges to change their rules, including their listing standards, the criteria that a publicly traded company has to meet and continue meeting in order to be able to sell stock across, through that exchange. Those exchange rules have to go to the Securities and Exchange Commission for approval before they are allowed to take effect. It wasn't always this way. Stock exchanges as private entities were largely self-regulating in their genesis, but as Judge Oldham in his en banc opinion explains, there were a lot of concerns about the level of market power that these exchanges held, and so Congress in 1975 amended the Exchange Act such that SROs, self-regulatory organizations, including stock exchanges, had to go get affirmative approval from the SEC before they could take effect. So, okay, Nasdaq submits this proposal to the SEC. What does the proposal say? In essence, it required that any company whose stock was traded on Nasdaq, they needed to have one woman or self-identified woman on the board of the listed company, and there also had to be one essentially racial or sexual minority. No joke, these were treated as fungible, as interchangeable, and on the board as well. And a company that did not meet both of these quotas would have to explain why not, would have to issue some kind of, essentially, in our view, a public apology for failing to meet the diversity quotas. Over and above that, there was a requirement that all companies listed on the exchange had to disclose the racial and sexual composition of their boards. And then there was also additionally a rule offering a free, essentially diversity recruiting service for 1 year, after which it was going to cost for companies that were not hitting their numbers. So the SEC proceeds by a vote of 3-2 in summer of 2021 to approve the rule, finding that the rule was consistent with the purposes of the Exchange Act. Interestingly, in response to, I believe, in response to comments filed both by our client, the Alliance for Fair Board Recruitment, as well as a couple others who participated in the rulemaking. So all of you admin law nerds, remember the importance of making an administrative record. The SEC looked at and ultimately declined to rely on evidence that Nasdaq had put forward that increased skin color or sexual, especially sex-based diversity on boards improved the corporate performance of the companies who had those more diverse boards. The evidence that we and others submitted, especially a literature review by Professor John Click at University of Pennsylvania, found that the studies that purported to show a causal relationship between the increased diversity along these identity politics lines, as well as the increased diversity along those lines did not actually have a causal relationship, a causal connection. At most, there was correlation, and it was equally consistent with the idea that companies could, it may well be the case that companies that are already successful decide to then invest in greater diversity along lines of sex and race, as opposed to sex and race diversity causing the greater corporate success in the first place. So the SEC again declined to rely on the proposed evidence, proposed findings that improve diversity, improve corporate performance. Instead, it said that we're doing this, we're going to prove this because certain important investors are demanding it. You can call this argumentatively the BlackRock echo chamber, that BlackRock, State Street Vanguard, and other institutional investors, well, asset managers and institutional investors were clamoring for this information so that they could make their own investment decisions. And the SEC found this to be consistent with what it said was the full disclosure purposes of the Exchange Act. All right, so on behalf of the Alliance for Fair Board Recruitment, we filed suit. We were later joined in the suit by New Civil Liberties Alliance representing National Center for Public Policy Research, and this is the Exchange Act sends these cases as an original matter to the circuit courts. The Alliance is headquartered in Texas and filed in the Fifth Circuit. That is the court that ended up having the exclusive venue to hear this case. I originally argued this, the petition for review in front of a three-judge panel of the Fifth Circuit in 2022, August of 22, and that panel concluded that two important things. One is that Nasdaq's rule and the SEC's approval of the rule was in fact consistent with the purposes of the Exchange Act, leaning very heavily on the purported disclosure purpose, full disclosure purpose of the Exchange Act. Additionally, the court also held that it did not need to reach the constitutional questions presented in this case. There's questions about is there an equal protection violation under the Supreme Court's Fifth Amendment case law, or is there a First Amendment violation from, say, compelled speech, compelled controversial speech, essentially. The panel held that there was no state action here. This was, after all, a proceeding initiated by a private actor. Yes, there needed to be some public blessing of the proposal in order for it to take effect, but that ultimately wasn't that different from a contractor needing to submit a building permit for approval. It doesn't make the construction of that building into state action there. We and our co-petitioner sought a rehearing of the case en banc. The court granted review granted rehearing of the case, and I re-argued the case en banc in front of the Fifth Circuit, with Senior Judge Dennis participating, because he'd been on the panel, and with Judge Ho recused from it, but we still had a total of 17 judges up on this case. That was in May, and now just this month, the Fifth Circuit en banc decided by a vote of 9-8 that indeed the Nasdaq board diversity rule violated the Exchange Act. So interestingly, the court sidestepped the question of the possible constitutional violations, saying that we don't need to reach the question of state action because we resolved this on the statutory Exchange Act grounds. And that aligns with the general tenor of the questioning and oral argument, where the predominant focus was on the Exchange Act and whether this rule did or did not meet any of the predicates for Exchange Act jurisdiction. On the Exchange Act itself, the majority opinion authored by Judge Andy Oldham and joined by 8 additional judges, took a pretty deep dive into the background of not just the Exchange Act, but the exchanges themselves, and went into some detail about, among other things, the market power held by stock exchanges that, as of 1975, for example, far and away, the New York Stock Exchange was the big dog in town, and in particular, that Congress was concerned about its potential abuse of market power to enrich itself and its members, the brokers and other members who participate in the NYSE, and Congress in particular found that exchange rules could be potentially abuses of that market power. And so the 75 Act, instead of, as previously was the case, allowed the Exchange Act had previously allowed exchanges to amend their rules as they saw fit, but then the SEC would need could review and revise, amend, change, delete rules. As of 1975, the exchanges would be required to seek affirmative permission from the SEC before a new rule could take effect. And what was the SEC looking for when it was going to approve or reject those rules? Well, Judge Oldham explains in the background to the 1934 Act that they were really concerned about, Congress was, in the first place, was concerned about things like market manipulation, fraud, protecting the integrity of the securities markets, and making sure that there wasn't, that speculation wasn't being encouraged. In fact, Judge Oldham quotes an authority comparing stock speculation directly to gambling as injurious morally if financially successful for the gambler, and injurious and morally and otherwise if it results in losses for the gambler. Which is a fascinating analogy. The ability of exchanges to the exchange rules were essentially focused on prevention of fraud, prevention of manipulation, prevention of gamesmanship, and with a couple of ancillary purposes as well. That is the background against which the en banc majority concluded that the Nasdaq rule was not sufficiently related to the purposes of the Exchange Act. That there was the connection with preventing fraud, manipulation, et cetera, was very tenuous. The connection with encouraging competition among exchanges, another core purpose, especially of the 1975 amendments to the Exchange Act, also not materially served by this rule. The fact that exchanges wanted it was not, or the stock exchange wanted it was not particularly relevant, and the court was also very took a pretty jaundiced view, I would say, of the idea that certain asset managers or institutional investors wanting this information to inform their own investment decisions was still just not connected to, in any robust way, those purposes of the Exchange Act. So one last thing I'll say doctrinally here is the court was very skeptical, very critical, in fact, of the argument offered by both the SEC and by Nasdaq that disclosure, disclosure simpliciter, was among the core purposes of the Exchange Act. Instead, the court tied any kind of disclosure rules that the Nasdaq, or implicitly the SEC, they need to be tied in with the identifiable purposes of the act. Again, principally related to manipulation and fraud, also related to promoting competition among exchanges, that kind of thing, and with some ancillary authorities, like relating to the integrity of corporate suffrage, and so on. So that's there's a lot more that can be said about this, Ryan, but I think I've gone into some pretty painful detail. I think the very last thing I'll say in terms of next steps is that Nasdaq has indicated in its public statements that while they stand by the objectives of the rule they put forward, they do not intend to seek further review, which at this point would only be the Supreme Court. And the last I had seen, at least, the SEC said it was reviewing its options, though of course, as we all understand, the SEC is looking at a change in leadership before too many more weeks. All right, so that's all the news that's fit to print, and then some. So I look forward to hearing from folks' questions.
Yeah, thank you so much, Jonathan, for breaking down the case for us. And to remind everyone here, you can put questions in the Q&A feature at the bottom of your screen, and we will get to them as we are able. So just start putting your questions in, and I'll ask a few questions to start us off. Yeah, so you touched on this at the very end here, but we are coming into a new administration with a new SEC. How do you anticipate that this new SEC will react to this case, and how do you anticipate the SEC will try to regulate exchanges and corporations along these lines and these issues in the next administration?
Yeah, so the SEC will still have, so there's two dissenting votes on this proposal back in 21, and those dissenters, when joined up with the SEC chair candidate that President-elect Trump has announced, Paul Atkins, I think they're likely to take a different look at this kind of issue. Excuse me, the two dissenters is still on the commission. Elad Roisman has since left the commission, but Mark Ojeda is now on. There are themes from Hester Pierce's dissent in particular that are echoed in the majority opinion of Judge Oldham for the Fifth Circuit. And so this is really Ryan, this opinion is now the freshest judicial take on the authority. I mean, it directly relates to the authority of exchanges to impose disclosure type mandates on their members, or excuse me, on listed companies. That's bracketing the disagreement over whether this is only a disclosure or if it's also a quota partially masked as a disclosure, because the Fifth Circuit was pretty skeptical of treating it as simply disclosure, but even as a disclosure alone, it was not adequate. There is the much of the statutory scheme relevant in the Exchange Act applies to both what stock exchanges do and what the SEC itself does. And so I would expect that with new leadership, the SEC is going to be looking very carefully at this new ruling from the Fifth Circuit before it proceeds to undertake anything that may be a disclosure-related rulemaking. Obviously, disclosure mandates for public companies has been a pretty hot topic the last couple of years. Not only on diversity but on climate too.
Well, great. This case was pretty close. It was in what, 9-8? Did you say?
Yes.
Can you speak to what the dissenting judges had to say in their opinions, or?
Yeah. So the dissent was authored by Judge Stephen Higginson of the Fifth Circuit. He's a very, very sharp judge. He's been on there, gosh, I think 12 years, 13 at the Fifth Circuit, and he repeated and he amplified much of the discussion of the issues that he had presented in the panel opinion. So Judge Higginson was on the panel that had ruled against the petitions for review, challenging the rule, so obviously he was a jurist who had thought pretty deeply about the issues presented, and he was able, his dissent was able to command 7 votes, 7 additional judges to join with him, but on a court with 17 eligible judges to vote on the merits in this particular case, that was obviously insufficient.
Understood. You answered. Moving now to some of our audience questions. I think you talked about this again at the end, but that you didn't think it was going to go to the Supreme Court. But what avenues do you think exist for this case to go to the Supreme Court?
So it would be, there are two, there's a grand total of, there's 4 parties to the controversy. There are the 2 challengers, Alliance for Fair Board Recruitment and National Center for Public Policy Research. And then the 2 respondents or defendants, you can say, are the Securities and Exchange Commission, which approved the rule and whose approval is necessary for it to take legal effect, take operative effect. And then, of course, the Nasdaq Stock Exchange was an intervener respondent, essentially. So the exchange has already said that they will not seek further review of this. SEC is reviewing its options. I think what I would add on this kind of thing, this is the type of case, as I've talked about, that is fairly it's fairly detailed in terms of grappling with the administrative record here, going into what we and others put in front of the commission at the stage where it was deciding whether to approve the rule or not. And that is the type of case, or among the many types of cases that traditionally the Supreme Court is pretty hesitant to take up. There are a couple of issues of law that of the type a court potentially could be interested in. One of the thing that influences that kind of cert analysis is the prospect of a split among the circuit courts of appeal. You can't have, because of how the Exchange Act channels direct challenges to a rules approval into a single circuit court, you can't have, not normally at least, a circuit court split on one saying this rule is legal and the other one saying this rule is illegal, or the approval of it was illegal or illegal. So that may complicate the circuit split question a little bit, but without the SEC seeking cert, or potentially Nasdaq changing its mind and seeking cert, those are the only ways that this could get up to the court. Gotcha.
Could you discuss whether the major question doctrine was a key to this case or dicta?
Yeah, so no, that's a great topic. I've not gotten as much into, which is that or at all yet. So Judge Oldham's opinion explains that the major questions is the kind of thing where pinning down the holding versus dictum question can be tricky. In this case, as is often how it's invoked by courts that seek to use it, it reinforces a conclusion that the court may have come to independently. And so reinforcing where does that fall on the line between holding and dictum is tricky, to be honest. But the discussion itself I think is worthy of notice. So the Judge Oldham says that this rule raises questions of vast economic significance, political significance, and also important questions of federalism. So on economic significance, he of course points to the $25 trillion in public company stock represented by Nasdaq. He admits that this doesn't make every Nasdaq rule a potentially major question, but it's a real factor. That's economic significance. On political significance, he pulls directly. I should fly. Here we go. Perfect. So the political significance, he says, okay, this is quoting Nasdaq. These rules came in response to, quote, the social justice movement, unquote, as an attempt to increase, quote, diversity and inclusion across public companies. So his one sentence of commentary on this in the opinion is, we can think of few more politically divisive issues in the nation. And then goes on to this very sly compare quote, comparing Justice Thomas versus Justice Sotomayor in the Harvard case, the Students for Fair Admissions case. Justice Thomas says, he quotes, it has long been apparent that diversity was merely the current rationale of convenience to support racially discriminatory admissions programs. And then Justice Sotomayor, diversity is now a fundamental American value, housed in our varied and multicultural American community that only continues to grow. So politically significant. And then I think the last thing to note here is that this is insofar as it's not just a disclosure mandate, and it wasn't, the attempt by Nasdaq to get into the substance of corporate governance, like how corporations organize themselves and the relations between directors and officers, owners and directors and so on. That is primarily an issue or a realm of state law. That's traditionally a question of state law. Now, the fact that you have a federal law, or in this case, federal approval of a private rule that intrudes into that question of state law, does not automatically make the intrusion like unlawful or illegitimate, but it does it does suggest that Congress would have only meant to authorize that intrusion if we can clearly read that into the text of the Exchange Act. And there's nothing resembling a clear statement in the Exchange Act that this kind of intrusion is appropriate, as contrasted with there's a statutory piece of, I believe it's within the Exchange Act, introduced by Sarbanes-Oxley, that does touch directly on corporate governance, where Sarbox requires that audit committees, so a subset of a corporate board, have to be independent from the company. They can't be insider directors like CEOs or what have you. So that is an intrusion into the traditional state realm of corporate governance. However, it is also one clearly stated by the federal law, and thus, even were it a major question, like it was a pretty major question, it would satisfy the Major Questions Doctrine because it was in fact clearly stated.
Understood. Are there any plans to challenge other SEC disclosure rules if there's no appeal in this one?
So, I mean, the big one, the elephant in the room here is really the ongoing challenge to the SEC's climate-related disclosures rule that this outgoing administration had promulgated, and requiring all public companies, issuers regulated by the SEC, to make certain climate-related disclosures. And there, so we, I was going to say, but we represent, Boyd and Gray represents the only public company that is challenging the rule, Liberty Energy. This CEO was just named by President Trump to be Secretary of Energy, Chris Wright. And there's several other challengers to that as well. That challenge is currently pending in front of the Eighth Circuit Court of Appeals. And so while this is what the Fifth Circuit has held here, will have some relevance. Like there's some common questions. There's also differences. As we're representing a party in active litigation on this, I'm not going to opine further on that one, but there could potentially be other other challenges in the offing, especially in the event that the commission's new leadership, as of sometime in 2025, if they were to choose to go that route, although Commissioner Peirce at least has expressed some skepticism of that approach.
Our next question is, what have been the reactions from some of these listed companies who are on the Nasdaq, who are no longer burdened by these rules about their board makeup, etc.?
So in terms of direct reactions to the ruling, I'm not completely certain. What I can say is I expect that a lot of companies are really looking for opportunities to essentially get back to neutral in questions of the culture wars, cultural controversies, and the like. You see this with a variety of public companies, like Boeing, for example, Walmart very recently, other companies that are publicly stepping back from DEI initiatives. And this, of course, is a very high profile attempt to impose a form of DEI across all the I think 3,300 or so companies that are listed on Nasdaq. So I think for I think for a lot of public companies that are looking for off ramps from getting into from having to be in the identity politics diversity game, and for ones that were never that high profile loud about it in the first place, they can walk away from it pretty quietly.
We have one more question in our queue here, so if anybody else has questions, please throw them in. Have you heard or seen that this decision is now impacting official or unofficial positions on the same topic by investors or proxy advisors?
Yeah, so this is, I'd say this provides pretty relevant, deep background for this. The responsibilities, the direct holding here goes to the powers of a stock exchange under the Exchange Act, and kind of derivatively the SEC's oversight authority over stock exchanges. The rules, statutory and otherwise, that govern how asset managers, proxy advisors, or institutional investors, how they act, they're going to be different. Each has their own regulatory regime, but one of the things that I do believe that it should cause, to the extent any of those actors are invoking diversity on the basis of these identity politics categories as a reason for casting proxy votes a certain way, voting for directors a certain way, advising on the casting of proxy votes, whatever it might be, they need to think really carefully about whether they can continue to rely on this easy equation between identity politics diversity and what are the things that most investors care about, or that the public is concerned with. Is a lot of these pushes for diversity are grounded in exactly that, or at least connected to, some could argue it's a pretext, connected to the body of literature purporting to find that connection between identity politics diversity and corporate performance. But this was including, for example, there's a famous McKinsey study to this effect, I want to say about a decade ago. That McKinsey study, if I'm connecting this correctly, was also recently subject to a pretty substantial replication crisis, where an economist looked at the same data and was unable to replicate their results. There's been a lot of critiques of that body of literature, and even the Securities and Exchange Commission, the same SEC majority that approved this diversity quota rule, they refused to find that there was that connection between identity politics diversity and improved corporate performance. They refused to rely on that as a basis for this. So it really ought to make those other players think twice. And I would add, at the federal level, when it comes to putting pressure on companies to change up the composition of their boards on grounds of race or sex, especially in the case of race, that's potentially an issue for liability under Section 1981, outlawing racial discrimination in the provision of in private contracting, as this arguably fits under, and possibly also a conflict with Title VII. Title VII, I'm summarizing a cloudy area of law, often does not apply to corporate directors, but it does sometimes. And in those occasions, there may also be a Title VII issue.
And speaking of that McKinsey study, we actually had our in-house counsel network hosted a webinar 2 weeks
Yes.
ago on this topic. So if anybody wants to hear more about that and delving into the data there, then I encourage you to look on our website under the in-house counsel network.
Well said. I saw that. I'm sure it was a good event.
Mhm.
It's a great topic.
Yeah, absolutely. We have one last question that got put in here. It says, has there been any fiduciary related, e.g., derivative actions related to this, and with what outcomes, if so?
Yeah, so there have been a few actions um, against uh, against a few different public corporations saying that they breached various duties in failing to have sufficiently diverse either boards or workforces. I, I don't have I don't have a good mental map of those full things. One thematically, one thematically related thing I would note is um, a securities fraud lawsuit that we have live right now, along with America First Legal and Lawson Hub Gonzalez, that alleges that the Target Corporation, the big retailer, breached or made misleading statements in its in various securities related statements about its things like monitoring of social and political risk and how it handled various ESG and DEI programs in ways that gave rise to the ultimately really disastrous LGBT Pride campaign last year, where we've alleged, and the court just found plausible, the stock company of the company dropped precipitously by billions and billions of dollars in the wake of that whole mess. So thematically, it's in a similar space. Though of course it's a separate issue. That's also pending in the Middle District of Florida right now.
We'll look forward to seeing the outcome there. Jonathan, do you have any closing thoughts on the case or anything before we close shop today?
Yeah, I would say that this case presents a really fascinating example of something that at least in my firm, I don't know if anyone else says this, of the like abuse it and lose it idea, which is attempts to abuse power, whether public power by a regulator or in this case market power by a self-regulatory organization like a stock exchange, overreach has the result of inviting judicial rebuke and a hemming in of previously enjoyed power in ways that a more sort of modest extension or exercise of power might have been able to survive. So I think it's fair to say that the Nasdaq Stock Exchange and the SEC in different ways abused some of the power they enjoyed, and now they've lost it as the Fifth Circuit is now held en banc.
Perfect. On behalf of the Federalist Society, Jonathan, thank you for being here. In behalf of the In-House Counsel Network, thank you and all of our audience for joining, especially with those great questions. We welcome listener feedback by email at info@fed-soc.org. And as always, keep your eye on our website and your emails for announcements about upcoming webinars and other events, including our In-House Counsel Network Conference, which will be held at the Ritz-Carlton in Chicago on June 6th of 2025. It'll be our fourth annual conference, and we're very much looking forward to it. Other than that, thank you all for being here today. We are adjourned, and Merry Christmas.
Thank you, Ryan. Merry Christmas, everyone.
Bye-bye.